Yeah, so I'm really super thrilled to be here at University of Manchester at the gracious invitation of John, and very grateful to be here with David as well. And so we're going to be talking about a comparative US and UK analysis of software, fintech, AI patents, and we just had a conversation this morning, very a lot of similarities, but also a lot of fascinating differences, and I think in this day and age, AI in particular is going to be a major thing. It's already revolutionizing a lot of technology, daily life, and so we are going to take a dive into how to protect it, and that result will impact maybe the economy and the industry of these innovations. And so I'm going to just do a quick, brief bio introduction of myself. I am currently a American law professor in Oklahoma City University School of Law, but I do also have a electrical computer science background and an LM from Berkeley Law, but also I have an LB from University of London. So very interested in discovering more about the IP legal landscape here in the UK. And I practice at law firms I've been in IP law for nearly 20 years. I've been at various AmLaw 100 law firms in America, doing an assortment of different practice, legal, IP, antitrust, entertainment law, working on those cases. I clerked for Judge Roy Payne in the Eastern District of Texas, and he's a judge who's construed the most patent claim terms, and he's close to 10,000 now. And also a judge in Indy Cal, a judge in the District of New Jersey, and the most senior PTAP judge. And then David and I will talk about what a PTAP judge is, an APJ, and maybe the equivalent in the UK where there's a specialized IP judge. Then I was also a patent examiner at the US Patent Trademark Office for more than 5.5 years. My art unit was business methods, so I specialize in finance, banking, insurance, and so a lot of that, is fintech nowadays, and it's been under fire as not being recognized as being innovative, and a lot of problems under this one statute called 35 U.S.C. 101, and so that's preventing allowance, but it's a very innovative space, and I think the thing that should be recognized about it is its potential to be very game-changing in terms of a lot of the things. And John Squires, he was recently appointed as nominated to be the USPTO director, and then Howard Lutnick, he was with Cantor Fitzgerald, named inventor on over 800 patents. All of them are fintech, very business methods for sure. And then John Squires used to be in-house IP counsel at Goldman Sachs, and when you hear Goldman Sachs, not a tech company, right? It's an investment firm, and so both of them are very much champions of maybe business method patent innovations. And I was editor-in-chief of the Journal of Patent Trademark Office Society, and then in addition to being having an engineering background, I'm a fiction writer, filmmaker, so I understand the IP holder perspective as well. And then you could email me at that address, and then David, I don't know if you wanted to go over sort of your background. I just took your page.
Yeah, sure. So I'm a partner in Marks & Clerk, specialist patent trademark company. We've got offices throughout the UK and offices internationally as well. My academic background is from the University of Manchester. I was here for many, many years. So my background was computer science and maths as an undergraduate, and then that was a joint honours degree, and then I bridged that boundary between the two for another 5 years. So I did a master's in automated reasoning at the maths department when it used to be the maths tower, and then I switched back to the computer science department for my PhD, but pretty much doing the same kind of stuff, so automated reasoning, the boundary between computer science and maths. I've been a patent attorney for probably, close to 20 years now, and my specialism has always been software and AI. I think reasonably unusually, when I started in the profession, at least, and in the UK, and I suspect this is less so in the US, I suspect there's been software patent attorneys for a long, long time, but I think there weren't many computer scientists as patent attorneys when we started. That is inevitably changing now as technology shifts towards software, but I have a huge amount of experience of handling software patents and AI, inevitable shift towards AI in recent years with my academic background, and being reasonably good and useful for doing that. My practice has been dominated for quite a few years now by two major applicants who are both, as it happens, US-based, handling European prosecution for them. So one major software company and one biotech company, but I handle their bioinformatics portfolio. So I have slightly, as patent attorneys tend to have, a slightly weird niche, specialist interest in biotech, as it happens, but biotech with software. So steep learning curve over the years, as it always is when you pick up a new technology. I'd say kind of probably the most interesting thing about being involved in software as a patent attorney is that you get to know a bit about pretty much everything in the world, because software touches everything, so you have to dig into different areas of technology. So yeah, so that's kind of my background.
And can you tell the audience about, it was very impressive to learn that, and maybe you drove this effort at Marks & Clerk, you issued these AI reports, and you definitely are the firm that is the most accurate, the most knowledgeable about AI, and almost at the cutting, bleeding edge, like everything about what's going on for AI.
Yeah, sure. I mean, so I guess this was sort of born out of frustration that AI became a big deal and everybody started saying they were an expert in AI, and we knew that we were, because we actually handle, we work for leading companies in AI. But how do you distinguish yourself from a bunch of other companies that say, hey, we're experts? So we have done every year now for probably the last 3 or 4 years a really deep dive into artificial intelligence patent applications, patent filings at the European Patent Office. We've looked at, as part of that, the reports. I think if you're interested in the area, then there's lots and lots of different information in there. But one of the key drivers for doing it, if I'm completely honest with people in the room, is that we wanted to get some actual data that said we are genuinely experts, and we did. We found that the data did back up what we thought. So we're the leading filer of AI applications, and we also have a significantly better success rate than the average. We have the top success rate of any firm for allowance for patents relating to artificial intelligence. And we used as the basis for that a WIPO definition of artificial intelligence. We have an information services team that has access to huge amounts of patent data. So we extracted all of that data. I think we're 50,000 items in the data, and we did lots and lots of analysis on that. So yeah,
wow.
Thank you for the opportunity to plug our expertise. That's appreciated.
Absolutely phenomenal. Yeah, I think that Marks & Clerk, the leader, and really David being the major reason for that. So that's super exciting to be with someone of that level of expertise. And so a lot of those issues that David and I were talking about, we're probably going to organize it into a series of 8 different categories. And the first is subject matter eligibility. Basically, that's maybe the law, the statutes that exist out there for what you can actually patent, and there are differences between the US and the UK. Software patent allowance, we'll be talking about the law and the strategy of that. And first, in the US and the UK and Europe, there's a statutory law, there's also case law, and then there's also strategies that you adopt in order to overcome examiner applications of that case law. And then we're going to talk about fintech patents specifically, and I was a business method patent examiner for more than 5.5 years, so very intimately knowledgeable about a lot of the approaches that you adopt and how to overcome rejections, because I've been on the other side. And then AI, we'll talk about AI patents and that landscape, and post-grad challenges. So, and in the US and in the UK and Europe, after you get a patent issued and allowed, There are, maybe some procedures you could adopt to challenge their validity and maybe get them invalidated. And also in patent litigation, once you have a allowed issue patent, you can assert that in various tribunals like the U.S. District Courts. And then in the UK and Europe, there are specialized bodies like the IPC, and then there's like a patent court. And then now, semi-recently, there's a body called the Unified Patent Court. And so David will speak on that. And then patent legislation. So in the US, there are potential reforms right now. Really, I think it has to start from Congress because we have a very active IP subcommittee, and there have been in the past reforms floated for 101, but they haven't gone through. And then David will talk about how that might be very difficult in the UK or Europe. And then finally, we'll discuss some parting thoughts, maybe mention some policy considerations, and then talk about AI, because AI really is AI is the future. It's the present. It's happening now, and I think it's. I was telling Rachel earlier, it's very much like the internet and very pervasive, and so I think it's going to be something certainly that will define our daily lives, and so patents are a very big part of it. And so launching right into subject matter eligibility, in the U.S. we have this one statute called 35 U.S.C. 101. It's very unclear, and then there's this one U.S. Supreme Court case called Alice. There's another one called Mayo, and so those cases have been combined into it's called the Alice-Mayo framework. So there's a two-step approach, but it's very confusing, and there's maybe like 30, 40 federal circuit cases going one way, 30, 40 going the other, and SCOTUS has not weighed in on this issue since Alice-Mayo. So it's very chaotic and very complicated for patent examiners to understand. The vast majority of patent examiners do not have law backgrounds, and so I remember my lab, it was like 2/3 lawyers, and so you really need to be a lawyer to understand maybe the more sophisticated things about the Alice-Mayo framework. And lowest allowance rate at the USPTO, I was talking to David earlier, I think it's in the low double digits, definitely lower than 20%. When I started out, I think my allowance rate was like a single digit, so very low. I was joking with David, I was telling him like the 36XX R unit, that's where patents go to die, because you might overcome the 102, 103 prior rejections, but 101, very difficult, very, very challenging to overcome. And so a lot of confusion, and I was, and then there's no specialized courts, general judges, but there are some knowledgeable patent judges in EDTex, Eastern District of Texas, and at the PTAB, there are administrative patent judges. And so for David, I was wondering in the UK and Europe, what sort of like the statutory framework that has to be followed, and maybe challenges that you face in order to get something allowed.
Sure. So in the UK and Europe, the statute is effectively identical, and there is a lot of confusion, and I think it's really not surprising that there's a lot of confusion. So the statute says there's a bunch of things that are excluded from patentability, and the most relevant ones to this discussion are computer programs, mathematical methods, business methods, and presentation of information kind of skirts along these topics as well. So these things are excluded from patentability, so that seems pretty clear, but the law also says that they're only excluded from it insofar as something relates to it as such, which is super helpful, super clear. I'm sure you'll agree. And there's no definition of what that means. And actually, I say this jokingly, but we actually had a conversation earlier where I think actually this is the right way to define the statute, but we'll perhaps come on to that later. But what it means is that the definition is left to the courts, to the case law, and is provided by the case law. And that means that if there's an opportunity for it to be a bit more flexible, for it to evolve, and the way that happens in the UK is you have the courts defining, decisions are made, and that sets the framework that the Patent Office then has to follow. In the European Patent Office, to get a UK patent process, I should step back. There's two different ways you can apply through the UK Intellectual Property Office, or you can apply through the European Patent Office, and then that is examined centrally and then can become a UK patent, and exactly the same as a UK patent granted through the UK Intellectual Property, same effect. So the European Patent Office, the case law has evolved through the boards of appeal, so there's cases that are examined and then appealed, and then they also have the enlarged board of appeal that very occasionally hears cases where there's an interesting point of law or a divergence in the case law, for example. So in Europe, Europe's a bit strange in that there is no sort of effect of a board of appeal decision. It doesn't have to be followed by anybody, but this is the boards of appeal decisions are kind of brought together through the guidelines for examination in the European Patent Office. And so what you get is this kind of, where there is consistency and agreement from the boards of appeal, then that comes together in the guidelines, and then that's what the examiners will follow. Examiners diverging from the guidelines is an extremely difficult thing to make happen. The test in the European Patent Office, there is divergence between the European approach and the UK approach here, even though the statute is practically identical. It's for a technical solution to a technical problem. The UK test is that you need a technical contribution. So, does that really move things forward from is it one of these insofar as it relates to one as such? Maybe, I suppose. Now you're looking for something technical, but you still need to know what technical means. But we are fortunate in Europe, I think, and here I think there is a difference to the US in that it is really consistent. There is a consistent approach that you can follow. There isn't divergent courts making divergent decisions. And so I think we do have a really nice framework that can be followed, that gives you predictability and consistency. Of course, there's always edge cases, but if you're not at the edge cases, then you know pretty much certainly what's going to happen, subject to the prior art.
And then the BPO or BOA is sort of equivalent to the PTAB, maybe in the US.
Yeah, right. So it's part of the patent office.
Gotcha.
It's actually independent from the examining division, but it is the body that sits above the examining division. It's not part of the courts.
Right. Yeah, that's really fascinating what you were talking about in terms of what a technical contribution means or a improvement to technology, and that leads us to talking about in the U.S. when you're trying to get a software patent allowed, that's also a very difficult thing to define. And I remember you were talking about how maybe a sure way to guarantee that you're dealing with something technical is to argue that it's something about a chemical process or something hardware, something tangible, something physical. And in the U.S., there used to be this case called the Bilski, and that was focused on the machine or transformation test, but now replaced with the Alice-Mayo framework. A lot more confusion because it can be a abstract method as long as it's integrated into a practical application or applying or improving a technology. But many times the applicants, especially in the fintech space, they say, I'm stock trading, I'm improving insurance calculations, I'm doing these things, and I'm improving the technology of performing credit card transactions faster. But that's not really technology. They can always argue that this is technology, but when it comes down to it, I think a technology is more about maybe hardware. And then when I was an examiner, I was always telling the applicants to focus on granularity. So pixel level, when you're talking about image processing, and I think in the UK there's an equivalent. And as well as, an extreme example is like electrons, right? Like when you get down so granular, so detailed that it's impossible for a human being to manipulate electrons, right? Or like current. So the more granular you get, I think it's a much stronger argument for allowance over software. And then the strategy is really trying to talk to the examiner with an interview, having a minimal record, and not making overly lengthy legal arguments that are pages and pages, because the vast majority of examiners do not have legal background, so it's lost on them. And even the ones that do, it's like you can't really. And we were talking about this morning. Like the PTAP cases are not binding. They're not really things that the examiners have to follow. So you are wasting a lot of maybe argument space and time. So what I found effective was when applicants actually have a phone interview or a conversation. So in the UK and Europe, it must be when you're talking about maybe something that's technical, there might have been more categories that have been better established, but still there might be some ambiguity perhaps.
Yeah, I think it's really interesting when you talk about the European approach and the US approach. On the face of it, they sound really, really close together, really similar. One thing that I think is really interesting from our research, our AI reports, we looked at applicant filing country, and and what we found in that was that, and this is specific to AI, but I'm certain it's more generally applicable, that US applicants underperform in terms of allowance rate compared to actually the rest of the world, not just European applicants. So US applicants allowance is under 50%, so it's 45%, and on average, it's AI again, but on average, the average allowance is about 55% for AI cases for everywhere else. And I guess maybe for context, the average allowance rate across all technologies before the European Patent Office is about 70-75%. So in terms of challenges, are there challenges with software patents? Absolutely, the allowance rate is lower for software patents than it is for technology generally. But also more than half of patent applications in AI get granted. So it certainly isn't the case that you can't protect these kinds of things. But so why I think this is interesting, the allowance rate for US applicants, is if I talk about the UK approach, it's the technical application and technical implementation. Technical implementation is about tying to the hardware. Right. It's really similar. Technical application is about kind of tying to underlying technology. Right. There's case law of the European Patent Office that says low-level features are what you need, high-level features are a problem. Right. And so text, they consider that to be a high-level feature. So it sounds like they're really similar. And certainly, I think they've come closer together in terms of approach. Bilski was completely different. Right. Machine or transformation just was completely irrelevant to the European approach. Whereas now the Alice Mayo framework, I think, gets you a lot closer. Right. But there's something's going on to underlie that difference in allowance rate. Mm-hmm. And I think it really is this difference in the US approach versus the European approach. Right. So in Europe, the framing is really key during drafting. If you frame your invention as the right kind of thing, the things that are technical, the applications that are technical, then you've got a decent chance. Maybe an example is helpful. So, for example, if you had a better way of processing financial data securely, I think framing that as all about the financial data in Europe, pretty low chance. But if you frame that as all about the secure processing of data, then that starts to become more possible to protect. Right. So yeah, there is an approach. There is an approach that looks, on the face of it, quite a lot like the US approach. But I think we find that framing, we just come at it differently when we're looking at it for Europe. Much more detail about how things operate. Right. That tends to be what we see as European practitioners, is what we want to put in, compared to what US practitioners tend to have in because of the US approach. Right. It's certainly not, it's not a criticism of you, it's just, I think, highlights the difference in approach. So, yeah, it's come a lot closer together, but there's still definite differences. Yeah,
that's a staggering difference, just in terms of allowance, and I think what you were talking about, the complete, divergence in drafting and how to put together a patent application is so widely different that I guess that makes a lot of sense too, because like when you examine it, you're dealing with a whole different set of assumptions and a context that's completely different. So I feel that makes a lot of sense, and so maybe maybe a way to increase the allowance rate in the U.S. is to try to model things after maybe how the UK or Europe does it.
Yeah, my key advice for anybody in this kind of field is if everybody's interested in basically in the US market, of course they are, it's a huge market,
right.
And the European market is also a huge market and very interesting. So but my key advice, and it isn't just because it benefits my practice, but it is get advice from both of those jurisdictions right at the start in drafting. It doesn't have to be drafted by both, but get some input from, if your European attorney is drafting it, get some input from a US attorney, because it's different, and they'll think about different things, they'll frame it differently, and similarly the other way. You really do want input from both directions right at the start, and there's obviously a cost to doing that, but it will save you money downstream. So I think that's my key strategy.
Right.
Is what I'm evangelical about that
right,
as an approach. You heard me say that.
Right.
In fact, when we met, I think that's that was my message then. It's still my message today.
Absolutely. No, I think it's very wise advice for sure. And then you were talking about how if to really bring out the technical innovation, the technical improvement. For example, if it's like data security, you focus on the maybe encryption or things that are very technical. And then for fintech, I think especially because I was a business method patent examiner for more than 5.5 years, all the applications I examined were definitely in the field of I called it FBI, finance, banking, insurance, but a lot of the cryptocurrencies, blockchain, NFTs, stock trading, all that stuff. And so in the UK and Europe, it might be more challenging to try to extract something that's technology based, and then based on my time as an examiner, I found the first thing I was mentioning was a very granular integration into something most of the time hardware based, right? Something that's like pixels or electrons or current, something that you can just say no way a human being can do it. It has to be something that is on the device level. And then another approach was a very specific order combination arrangement. And so there's one federal circuit case called BASCOM where when I teach it in patent law, I draw like a server and a mountain and a river and another server, and it matters where you place your servers with respect to one another, and it's a different. So a lot of times in a claim they will say, oh, there's a server, but it can be just arbitrarily placed anywhere. And when you get more and more complicated, especially for something involving communications, your hardware really needs to be in a very specific configuration, and that's the other approach too, where I've seen applicants overcome 101. And then the third is maybe conservation of some type of tangible resource, be it power or energy or something tangible and physical. And so that sort of is related to how you can, in a lot of these financial systems, you can configure your hardware in a way that just makes the processing of a transaction a lot more efficient, a lot more streamlined. And that too, because, especially if it can serve something physical, then you can make the argument that it is an improvement to technology and not an improvement to the abstract idea, of making transactions faster. And then finally, we're seeing this now, especially in the UK, I see this all over the place, where you have a very special type of card, and then it's really, it's not about although you can use that card to perform certain business methods and financial transaction processes, it's the hardware in the card, right? So when you're drafting it, you're really trying to focus on maybe the circuitry, and it really shouldn't even be in business methods, probably should be in a circuit art unit or hardware art unit. And as a result, you don't even apply the 101. And so I was curious, in the UK and Europe, are there similar considerations for trying to get a fintech innovation allowed?
Yeah, so fintech is it's challenging for sure in the UK and Europe. So again, from our AI data, because that's what I have, there's a 20% allowance for related to technology in kind of banking and finance. So it's a significant drop when you're in that kind of technology area. But again, 1/5 of them are allowed. You can get granted patents in this area. It's not that there's none. The real challenge with this kind of technology area is that the technical application approach, the kind of, it's related to chemistry and that's clearly technical, or it's image processing and that's clearly technical. Here, it's fundamentally related to a business method and that is not technical. So that relatively easy out of excluded subject matter of, look, I'm just doing it in a technical context, that's not available to you. You can't go, oh look, finance data and you're home. So you have to find something else. So you need to look for something like, for example, data security or some other technical problem that isn't about the finance data. And that's kind of your way through these kinds of application. The technical implementation is another way. Technical implementation, again, is tying to the hardware. It's kind of interesting on here, and I think maybe this is one of the big differences between the US and why there's that difference in allowance rate. We see a lot US drafted applications which talk about, and we reduce power consumption, or and we reduce memory. And that often doesn't work in the UK because in the UK and Europe, the response will be basically, that's lovely, but you're reducing memory usage or power consumption in solving a non-technical problem. So it doesn't matter, it's still non-technical even though you're reducing power consumption. Right. So you need to kind of bring it away from the financial data and tie it to we are generally improving power consumption because of data processing, and separate out the financial aspects, and then it can be protectable. If you are, if it didn't matter what the data was, maybe that's one way to look at it. If you save power and it didn't matter that it was financial data, then you could still protect it. But if it matters that it's financial data, then you're probably in trouble.
That's fascinating because I remember there were some applications I dealt with where it was like they're trying to argue there was a manipulation of the signal, but that signal, like when you drop a phone or something, it would be ultimately data to be used when you're trying to trade in a phone or evaluate it, give it a monetary value. And so ultimately, I think under that approach, it's just financial data. It doesn't matter how you collect it, right? Even though you intercept a signal, and that was probably splitting hairs or adopting something that's really.
So it's a really nice example. So in that example. If there is a real-world signal that's being processed, and so that real-world signal usually is a good sign in Europe. If that real-world signal tells you a physical thing about the device, which it does, then that physical thing about the device, that could be technical. If that were known, so in Europe, if you framed it that way, that would probably be okay. If it happened that were known and all you had realised was, and I can turn that into a financial thing, then that financial bit on the side, that won't get you home, that won't be okay.
Got it.
So it's a really nice example.
Yeah, I think it's that we see the rubber meet the road and really see the differences between maybe the US and UK and Europe approach. And then, turning to AI, I know at the USPTO there's this whole separate AI R unit, and I was in business methods, but I think they might apply, different techniques to examine it, certainly under 101, and so I pretty much just repeated the same approaches where the more you can integrate into technology or argue a order combination or conserve some physical resource or improve efficiency. But I know especially because of your very deep expertise on AI, did you notice and you were mentioning this morning about in the UK there's almost like this hesitation to allow things that are linguistic or text processing and things like that. And so those might be special cases in the UK compared to the US that for AI, especially because all the large language models and some of the stuff happening with ChatGPT and Claude and all those are really just like text processing, and so it'd be interesting to find out from you, like, where do you draw the line?
So it's one of those really interesting ones that probably made sense before AI, and now unfortunately the case law is there, and they sort of stick to it on text processing. Text processing is generally considered to not be one of the safe applications, but image processing is one of the safe applications. And what I find really interesting, and I've spoken to examiners, I've spoken to Board of Appeal members about this distinction. When you're processing an image with a neural network, and when you're processing a document, a text document with a neural network, it's in vector space. It is. You're not actually worrying about the words.
Yeah.
The case law for text processing being non-technical comes out of applications which were really about, oh look, I've understood that there's this grammatical concept and I can make use of it.
Mm-hmm.
And I think there's probably something in that not being technical.
Right.
But when you get to LLMs now, I would say you are processing low-level features
Right.
in exactly the same way as you're processing image features.
Right.
But my view, unfortunately, isn't the one that matters. The case law says that the text is not is high-level features. It's linguistic,
Mm-hmm.
and so it's much more difficult. But for AI, AI is fundamentally considered maths, and neural network is maths,
Right.
so it's fair enough.
Right.
So your starting point is that you're within one of the exclusions.
Right.
But it's really easy to get out of those exclusions if you're doing something that is considered a technical thing. So
Right.
if the input's an image,
Right.
you're good. You pretty much don't need to worry about the exclusions.
Right.
But if your financial data, it's a lot harder.
Right.
If your text data, unfortunately, then it's a lot harder too.
Mm-hmm.
The exception to those, again, is this technical implementation strand.
Right.
And the technical implementation for AI can be quite useful.
Mm-hmm.
This is the kind of classic example from the European Patent Office is if you use a CPU and a GPU, so a central processing unit, graphics processing unit,
Right.
and you have an algorithm, purely abstract algorithm, that's how to train a neural network, for example. Then if you divide up the operations so that you make best use of the properties of a CPU and a GPU,
Right.
and that you are tied to the underlying hardware, your invention is connected to the hardware itself,
Right.
and then you can be protected. So we have had, it is always harder to run a technical implementation argument,
Right.
but if you can run it, you always get significantly broader protection.
Got it.
So there aren't many companies in the world doing genuine, what I would call core AI, inventing neural networks.
Right.
Most people are kind of applying it to an application field.
Got
So
it.
quite often it's okay if your application field is one of the good ones, one of the technical ones.
Technical, right.
But technical implementation is something we've had a fair amount of success with.
Mm-hmm.
You can convince examiners, because the case law is so well defined,
Got it.
you can convince an examiner that actually if you are a technical implementation,
Right.
you can overcome those kinds of
Right.
objections.
Right, and as we were talking about this morning, it's, when you're talking about text, it could be something as simple as saying, I'm doing a manipulation based on optical character recognition. I'm treating the text as like an image as opposed to a piece of text, and then that might be sort of a very easier way to argue that there's technology involved.
That's exactly right.
Right.
Yeah. Where it becomes really interesting is where you have a hybrid. So your example of OCR in text processing.
Right.
What you might do is, say, use properties of the image
Right.
and the text alongside each other, and your invention is to do both of those.
Right.
So then, are you technical or not technical?
Right.
Bits of it aren't.
Right.
Bits of it are.
Right.
But there's this, if it's framed the right way, if it's thought about at the start about what the European Patent Office is going to do with it, then that can really help you with overcoming those kinds of objections.
Got it. And so the end product of after overcoming all the objections, there are and you're very enthusiastic. You tell your client, congratulations, you got the patent, but that oftentimes is not the end of the story, because even though you try to assert it in district court, in America at least, there's a lot of procedures that someone can initiate against you to basically invalidate a patent, kill the patent, and so that's why the PTAB has earned the moniker of the patent death squad. And the really hot procedure right now is called an IPR, inter partes review, So a lot of the NPEs, non-practicing entities, they drive patent litigation. So they're just companies that don't make anything. They just get the patents and they sue everyone under the sun. But the top petitioners, guess who? They're like companies like Apple, Samsung, Google, Meta. They are the ones filing these petitions at the PTAB to kill these patents. So you don't have a patent anymore, goodbye lawsuit, right? So you don't have anything to sue for. And there used to be a procedure called CVM, which was a covered business methods, but that has sunsetted. And that was a result of a lot of these like credit card companies, banks, finance companies, telling Senator Schumer that we're not in the industry of technology or innovation. We're just finance companies. And so we're getting sued all the time by these MPEs who have business method patents, but that's not our market, that's not our approach. So as a result, this procedure was created to allow them to maybe stop some of these patent infringement suits, but it wasn't really used as often. And there's a PGR process too, post-grant review, and that's more time sensitive. So basically, in the pharmaceutical industry, you have shorter windows. You need to get something that's published on the Orange Book, according to FDA. And so it's a procedure really almost exclusively used by these pharmaceutical companies. And then interferences in older procedure, re-exams, even certificates of correction. There's many different strategies that you apply. And then so I know in the UK and Europe, there might be only, and this is just a chart that shows you all the different varieties of post-grant proceedings that are available in the U.S. So that there's an asterisk next to covered business method because it's simply not recognized anymore, and it's sunsetted, I think, back in 2023 or 2024. And so in the UK, I know that maybe there's one main flavor, and that would be maybe an opposition.
Yeah, so the European Patent Office has an opposition procedure. I guess one of the key differences with the opposition procedure relative to in the US, well, I guess there's two. So one of the key ones is that it's time limited, so it's only within 9 months of grant that you can oppose a patent. What in software, at least, I think this has a big impact on the extent to which oppositions are used, and the percentage of patents opposed in software fields is significantly lower than in other fields. I can't remember the percentages, but I think it's sort of 4% rather than sort of 7% in other areas. They're probably not quite right, but there's a pretty significant difference. And what inevitably people, patentees do, because why wouldn't you, is they wait until the opposition period has expired before you sue. And what that means then is either you have to work out what you might get sued under and then oppose it.
Right.
And that's a hard thing to do, I think, again, particularly in software fields, because in software it's much less common, I think, to have a key patent, particularly for large filers. There tends to be more of a patent thicket, lots and lots of applications that generally cover a field.
Right.
And there's pharmaceuticals tend to have kill a patent, kill a drug, and everybody knows what it is, and they've followed it through, and then they can oppose it. So you get a lot of oppositions. Whereas oppositions in the software field, it is just a lot less frequent. It would be resource draining if they all started, if the big companies, the big tech companies all started opposing all of the other patents.
Right.
So we see a lot less oppositions. We do handle oppositions, but actually most of my opposition practice is in the bioinformatics side, which is unsurprising because bioinformatics is more on the biotech pharmaceutical type side, where that's just more what they're used to doing.
Right.
So we're talking specifically now not in the courts, and we'll come on to the courts next. But in the UK, there is also a invalidity proceeding before the Patent Office that you can use. It isn't used a great deal in my experience. Partly because certainly we have used it, but it's appealable to the courts as the next position, and basically whoever loses that now knows that it's something that's important to somebody else.
Right.
They know who that someone else is. So if you bring a proceeding before the UK Intellectual Property Office, you're going to end up in the courts anyway.
Right.
A lot of the time, companies tend to just skip to the end and get stuck in the courts.
Right.
But for smaller businesses where they're worried about particular rights and not sure about a particular right, then there are some useful procedures before the UK Intellectual Property Office.
Yeah, so what David is talking about is another avenue that once you get your patent issued and allowed, you can assert it in district court. In America, that's the primary forum or tribunal which you sue other parties for patent infringement, but there are ways in which the defendants can file a motion to dismiss for the patent being invalid under 101. And I remember when I was clerking for Judge Payne, I wrote an order that was like invalidating like 10 patents with over 1,000 claims under 101 because it was like very abstract. It was like a method for making a greeting card or something. And so and then in the U.S. there are other tribunals like the USITC. USITC doesn't reward monetary damages, but they do these exclusion orders that prevent a product from being shipped into the U.S. So for some companies, that might be more of a impactful award compared to money because like things like Sonos speakers or Apple iWatches, for example, and the PTAB IPRs, you can appeal them up to the U.S. Court of Appeals and the Federal Circuit. So there's a lot of strategy there for Federal Circuit appeals and writs of mandamus when you're asking a district court to do something, and SCOTUS appeals too, because like everything from the Federal Circuit goes up to SCOTUS. But SCOTUS only takes up if it's a patent or IP issue, something that would be like pretty major and that would change a lot of the case law. So it's very rare that SCOTUS would take up like a minor procedural issue for patent law. And so the question begs the question: do we need a separate specialized court or specialized IP judges? And that's a paper in progress of mine. I'm trying to propose a U.S. District Court that just specializes in patent law that would eliminate judge shopping, forum shopping, and the Federal Circuit is called the Federal Circuit. I want to call this court the U.S. District Court for the Federal District, and so. But we don't have one currently, and so the closest things are the PTAB, the ITC, Federal Circuit. It might be a learning opportunity to follow the UK and Europe systems to have specialized IP or patent courts. And I was maybe curious what David's thoughts were on how's that working out, especially with the IPEC, the UPC, Unified Patent Court, and then the various judges, I guess, at the high court level and others that do have a lot of specialized patent knowledge.
Yeah, I think it works quite well in the UK and Europe. I think there isn't huge amounts of litigation in software fields, and I think probably that's partly because of how well they operate, if that makes sense. So what I mean by that is they're very predictable. So lots of things, if you can predict the outcome of something, you don't need to use it as much. Right. So I think that is a big positive from the approach, and the approach is different in the US, as you touched on. So the UK has specialist courts, it has specialist judges. Right. It's a really small pool. I had a look at the patent court judges, and it's fewer than 10 that hear patent cases. We have the IPEC in the UK, which is the Intellectual Property Enterprise Court. It was introduced not that many years ago now, although it probably is. I think it was within my career at least. I'm definitely getting old when you think something is recent and is not, right? But that was designed for relatively low value intellectual property cases, sort of under half a million is what the guidance was. Right. And that was a judge who was very specialist. The Patents Court then is for higher value courts, but the clue's in the name, it's called the Patents Court. Right. That's what it's for. That's the fewer than 10 judges. They're all very expert. They understand the law. I guess one of the big differences that we touched on when we were talking about this before is, as I understand it in the US, you have a right as a defendant, I think, to be heard by a jury. And to my mind, that's a challenge for courts in the US handling extraordinarily complex legally and technically. The issues are complex in two different dimensions, and you have people whose educational background is probably pretty, it's certainly not at the right level to understand the complex technical issues, making a decision. And I do think that has been one of the big challenges in the US with the approach and how it's changed with time. And when you've got the approach in the UK has evolved. There's no, but it has been minor evolution, by a series of decisions over 30 years. And that's because you've got the same experts hearing it. They get a new, and again, going back to right at the start, this very open, and we're sort of getting into the next bit about the legislature now, but the very open approach to how the legislature was defined and letting the courts evolve that. I think defining an approach, thinking about all of the issues that might come up and going, well, this is what you have to do. I just don't think that's realistic. You have to see some facts and go, oh yeah, okay, those facts mean I need to think about it in a different way. But the UK courts, with the consistent thread through them, has meant that it's very much evolved. You mentioned the UPC as well. The UPC is a brand new court for European patents. That genuinely is brand new. That's not just me being old and confused. It's been around since July last year, I think. But again, the approach there has, I think, so far, everything I've heard has been extremely positive about the UPC. And there was some concern. Patent litigation is generally high value. Do I really want to trust a new court when there is literally no case law? But the approach that was taken for that was built for it to work, built to build trust. The judges are very experienced judges from all of the courts around. There's a lot of very experienced German judges involved in the court. There is a lot of flexibility built into it in terms of procedural options, but they are deciding patents that are granted by the European Patent Office. And actually, while there's no case law, to my mind, it would be crazy for them to not look to the boards of appeal, the large boards of appeal, and take that as their body of law. And that is what they've done so far. As I say, generally the UPC seems to be a great success. People are using it much more actively than I think people thought they would. There's been quite a lot of litigation before the UPC. It seems to be working well. But it's that approach again. It's get a consistent thread. And, and I think it is a model that could apply to the US. I think there are different challenges in the US because of the state versus federal approach. But the UPC has local divisions which are in specific countries. But the judges move around. It's a rotating pool of judges that are common to all of them.
So fascinating.
You still get your common thread, common approach, consistency. I think I might say that all local divisions always have, and it depends on the experience of the local division. So if you're in Germany, I think actually there's fewer of the central judges that are involved because the German judges are generally very experienced in patent litigation. But if you're in a country that doesn't hear much, if any, patent litigation, then there'll be more of the central judges. So you get real good, nice consistency. It seems to have worked, and maybe there's a model for the US.
Oh, absolutely, yeah. And I think we were talking about this morning how the patent litigators in the U.S. really want consistent, predictable decisions. So that's why they constantly file an ED text, and they know the judges there are very knowledgeable. They know the outcomes. But even Delaware, District of Delaware, is very active in patent litigation. They don't want to file in Delaware because the judges they can never predict what the outcome is. And again, going back to ED text, like there's a lot of really good trial lawyers who can use, sort of this American rhetoric of, say someone came onto your property, stole your tractor, like that type of mentality of the good old American ingenuity. And, you're convincing, like you said, jurors with lower educational backgrounds that might be more gullible. And then in the UK and Europe, they really don't have any jurors. They really defer to the judges with the specialized expertise. And I just think like my proposal at least is to eliminate all the forum shopping. You would just have the judges who know patent law, but I have this sort of like, there's various constitutional issues with it, but having like a technically trained jury to understand, and maybe even like, potential patent examiners or people with science engineering backgrounds to like be like a trained profession to evaluate, patent cases. And so you would have like a specialized jury and a specialized judge. And I think, what's happening in the UK and Europe is just really, I think something that we can model after, because I think it's effective right now. And especially for, because like they're all appealed to a body, the Federal Circuit, which deals only with patent law. I think it would just make a lot of sense to have the trial court level be, patent focused as well. So, but just really fascinating. I think the fact that like, all these bodies are specialized in the UK and Europe, and I think they're doing a good job.
I'm really interested in your view on Scottish, the Supreme Court. My perception from here is that the Supreme Court, the approach in the US seems to have completely flipped from Bilski to Alice.
Right.
Everything was just blown apart,
right.
And that was because the Supreme Court decided to take a case. So I'm really interested in your view on the role of the Supreme Court and how effective you think that is, and maybe slightly leading in my introduction to the question, but
it's such an excellent question, because that was for the longest time, like the body of practitioners and professors and judges, like they've been seeking guidance from SCOTUS for, especially after Alice Mayo. And that's the reason why the Federal Circuit, there's so much confusion. There's many cases going different ways. And there was an opportunity. There was with the American Axle case, but SCOTUS just didn't take it up. And, I think that they were quite busy with maybe more controversial, impactful cases that, they wanted to settle. Patent law might be really low on a totem pole. So I think, but I think, nowadays, and I think this is a good segue to legislation. I think that the most impactful change that would really change, modify the allowance rates, make fintech, AI, software patents easier to acquire and obtain, would be a change in the legislation, right? So the 35 U.S.C. 101, that's the currently existing statute, but Howard Lutnick, Cantor Fitzgerald, he was named inventor on over 800 plus patents, and all of them were sort of business method patents to John Squires, IP counsel of Goldman Sachs. This could be a potential business method dream team, and they might also be a catalyst to Congress to maybe come up with 101 reform. And there have been efforts in the past, and the approach, and I was telling you this morning, the approach was to focus less on maybe the nature of the invention, whether or not it's abstract, but focus more on how novel it is, and look at the prior art and make more of a determination based off of that, as opposed to just ruling something out just because it's potentially abstract or uses math or mimics human activity. And so when Andre Janke was director in 2019, when I joined the USPTO, he came out with these practical examination guidelines. And so maybe a lot of Squires could do the same thing to really provide a lot more clarity and guidance for examination. But this is not law. This is like, maybe like administrative, regulatory things that are really like the minutia, just really like small, like a guidance memo or something like that. And so I was interested to maybe learn from you in the UK. Are there any, is there any potential for possible legislative reform or new laws?
I I think this one's a really simple one in some ways, in that there's absolutely no chance at all. And I can explain why. So the European Patent Convention, which is what the UK statute is based on, and all of the other countries basically implements that statute. So that's why I say it's identical in the UK to the EPC. There was a decade of negotiation to agree that, because it was European level. So there's lots of different competing interests, lots of different countries involved in that negotiation. The Unitary Patent and Unified Patent Court, which has just come into place, that took nearly 50 years to be realised. It's been talked about for 50 years. These things are not easy to get into place, and renegotiating them is extremely difficult. But to be honest, I'm not sure we need it. So there's also no motivation in Europe to do it. What we have is it's not perfect, it's not flawless, of course, but it is a reasonably predictable, pretty applicable approach to what is and isn't protectable. So that leaves the case law, which is the only realistic way for there to be change. I said before that the UK courts have tweaked the approach over the last 20 years. It really is tweaking though, you know. It used to be in 2006 it was called the technical effect with the rider, and it changed to the four-step test then. But it's always been looking for a technical contribution effectively. It's just how exactly, what questions you ask to get to that answer. Right. There's not been this kind of really big change, as I would see it in the US at least. It's a reformulation. Right. The European Patent Office, the Enlarged Board of Appeal were asked by the President of the European Patent Office some number of years ago, not many in my mind at least, to answer questions about the approach, and the Enlarged Board of Appeal said, no, we don't need to. Right. There's no divergence, it's consistent, it's applicable, we don't need to. Right. So I think we have a good framework, a good approach, it works. I think this consistent thread is really helpful. Right. And the UPC, I said before, there is no case law really, but their approach so far seems to me to be the right one. Right. And that's that. Why would we blow that all up and just decide to make radical decisions? Right. Yeah. So that hasn't really happened.
That's truly compelling, because I feel like the saying is, if it's not broken, don't fix it. Right. Yeah. So like it seems for the large part, the approach in the UK and Europe is working, and so I think that provides a excellent model for America to maybe to emulate or change the law so it more resembles the UK European approach. So I feel that's a very, very strong point to consider, especially with all the confusion going on right now with American law.
I'm really interested in what you said about looking to the case law. Looking to the prior art more. The prior art. I think in the US you kind of separate. You ask first, is it technical, and then you move on to the prior art separately. Whereas both the UK and Europe, very clearly the European approach, and I think the UK approach too. There is some slight subtlety and difference there, but the European approach is there a technical solution to a technical problem, and the technical problem is defined with reference to the prior art. So there isn't this total separation of prior art and excluded subject matter. You have to look at them together. Right. So I'm really interested in if that is a line that if it can be integrated into one. Well, maybe there's legislative hurdles that they can't be. I don't know. That would be interesting to me.
That's a brilliant idea, and I think that was what a lot of the reform was moving towards. And I think what might be and this is like a paper in progress of mine, but basically I suggest, and Andre Yonko was thinking about it, but have a separate examination track, have a separate group of examiners, just do it 101, but then don't prevent it from proceeding to like 102, 103 prior art. But then have that be all lawyers or something, or people with legal background that can truly understand the nuances and sophistication of 101, and then have that, and then or maybe have more specific rules about that. But in other words, it's not an impediment, it's not an obstacle to allowance, and then effectively you are maybe examining both at the same time if you split it up, as opposed to you have to do one before the other, and That's really an amazing, I think, I think approach. And then sort of the parting thoughts. I think AI is really the big thing right now. And in America, there's even AI tools being used for patent prosecution. There's AI being considered as a subject matter for allowance for patents. And then the USPTO is using AI, and so and in the patent litigation, there's like these examples of I have the hall of shame of attorneys who have used AI and then relied on the hallucinations of these big cases. And then the ED10 local patent rules, they actually changed and said that anytime you're using Gen AI, you have to disclose it to the court. So there's like awareness that you have to do your due diligence and double check everything that you're citing and using AI to cite. And then, right now this is not patent law, but copyright law, but a ton of Gen AI copyright law cases going on, and issues like fair use, and cases in the past from there was one inventor. He wanted to Thaler. He wanted an AI entity to be an inventor, and so I was curious about like maybe in the UK and Europe, how's AI being treated, and how do you sort of predict it? How do you think it will be treated going forward?
I mean, certainly in terms of its importance to the world rather than to patent prosecution,
right.
It's going to become a significant part of. I mean, it is. The number of AI-related filings is multiplied by 4 since 2010 to now. It's a huge increase. So it's becoming more and more important in the world, and inevitably that means it's becoming more and more important in patents because it's there in more and more cases. The European Patent Office, I think, has dealt with it pretty well. They have a dedicated team who are, so the European Patent Office has examining divisions of 3, always for every case. You normally deal with one of them, but they've made sure that they have, for any case that's got an AI angle, they've got an AI specialist on that team. So even if it's in a chemistry unit, there's an AI specialist that joins the team, which I think is absolutely the right approach, and has helped and has shown good outcomes. My practice is probably 70% or more of what I do is AI related, and that obviously has shifted. I've always had software predominantly, but the amount that is AI has definitely shifted. You mentioned AI tools. They are coming into the job. They will be coming into the job. There's a lot that claim to make the job more efficient. I'm sure that they will at some point. Whether they are now, I think, is an interesting question. Yeah, I don't see it.
And also for maybe examiners, it's like you can get an AI to prior art search, very formulaic, right? And then I remember a lot of the office actions I wrote were just following a template, but and nowadays, I think a lot of the because Trump's executive order basically forced a lot of examiners to come back to office, so maybe a lot of them are going to private practice, leaving the USPTO, so there might be a need to create this army of AI examiner bots, and that I think it's becoming more and more of a likely reality of AI, but maybe the human beings who work like years and years for the government may not want to face that.
Well, I mean, people we obviously talk about these things within our business, and we joke about a future where a patent application is drafted by AI, you send it to the patent office, it examines it with AI, generates an examination report, and AI responds to that. You've just got AI talking to each other.
And an AI judge or
an AI judge. I don't, maybe I'm naive, but I think technology is nowhere near yet doing what actually I see as the core of my job. My job is partly about putting down the right words on the page, but actually the right words isn't just putting some words down, it's the right words that understands the commercial drivers of the business and protects those commercial drivers, and I think that is a lot harder to do.
Yeah, very human, creative, thinking outside the box, Inventors
know what they've done generally. They go, I've got this amazing thing. And one of the first things I always say to any business I talk to is, this is a commercial product that you're looking for, and there's a cost to that commercial product.
Absolutely.
And you need to first think is, why am I getting this?
Right.
And is it worth the cost? Because there is a cost.
Right.
And I think that is something that AI is a long way away from being able to really properly think about and ask the right questions and dig into.
Right value, right. Absolutely.
I think we're a way away.
Yeah, no, that's really fascinating. And then like there was a Professor Eugene Volokh at UCLA, he gave a talk at OKC, and he was saying how like he made a joke about Chief Justice robot, like Roberts, and things like, that might be the future. You never know. And I think the more, and there's also a saying too that like it's not AI that's going to replace a lawyer. It's like a lawyer who knows how to use AI that it's going to replace a lawyer who is resistant to it or just doesn't want to use it. So I think just like the internet, is one of those tools that's already revolutionizing the practice of law. And so I think it's all about like how we educate ourselves
It's interesting you say about the AI judge. So Colin Burrs, who spoke at the conference that we met at, he set up the intellectual property enterprise called,
right.
And he occasionally makes the popular press in the UK. And his latest making the popular press was that he used AI to help him write one of his judgments. And he was completely open about it. He said, I knew the answer, and it wasn't like I was asking it for the answer. I was asking it to just write it more efficiently.
Right.
But, he's starting to do that kind of thing. I think it's a tool to help people make judgments.
Yeah, it's like the perfect law clerk, and then you can always correct it, but it's also like an apprentice or student. You're training to do something. And
you say perfect law clerk. So the European Patent Office launched a tool not that long ago which allows you to access the case law, and it's a large language model interface to the case law of the Boards of Appeal. Right. And there's two different parts to it. There's the case law of the Boards of Appeal, which is incredible because you cannot go through all of the case law of the Boards of Appeal. You can't know all of the case law of the Boards of Appeal.
Yeah.
So for that, it's amazing.
Right.
But they also have an interface into actually the guidelines and the law.
Right.
And somebody ran a query on that to ask what the deadline was for doing something. They gave them the wrong answer.
Right.
So it's not
practice,
quite
perfect.
Yeah,
it's very imperfect.
Fortunately,
might be a good start. Right.
It's coming, but it's coming as a tool.
That's riveting. But that's it. Anyone have any questions?
Tim, David, thank you so much.
Yeah.